The Supreme Court of Guam is now in session. Will the clerk please call the case?
This is Supreme Court case number CVA19-019. Guam Police Department Major Fred M. Chargualaf, petitioner, appellant, versus Government of Guam Retirement Fund, respondent, appellee. Appearing for the respondent appellee is attorney Vincent C. Camacho. Appearing for the petitioner appellant is attorney Joshua D. Walsh. The panel consists of Chief Justice F. Philip Carbolito, Associate Justice Robert J. Torres, and Chief Justice Alexandro C. Castro. Attorney Walsh reserves 12 minutes.
Thank you. Good morning, Attorney Camacho and Attorney Walsh. At this time, Mr. Walsh, you are recognized.
Thank you, Mr. Chief Justice, and may it please the court. When an administrative agency adversely affects the vested property rights of a retirement fund member through a determination that conflicts with the plain reading of a statute and does so without developing a record to stand upon, that decision is due no deference and should be rejected. When a court reviewing an administrative decision also chooses to abandon the plain reading of a statute and does so using its own rationale not previously advanced by the agency, that court decision is in error and must be corrected as well. That is what has occurred here. At the heart of this case is the annuity calculation used to determine the benefit owed to Major Chargualaf, a career public safety official on the island. This court has directed that the statutory analysis begins with the statute, so that seems like a good place to start here. That is also the place that the Superior Court started. The calculation that we're discussing is dependent on the definition of average annual salary. That's at 4 GCA 8122. The Superior Court of Guam correctly explained that the plain language of that statute favors the interpretation of Major Chargualaf. That's a finding of the Superior Court that is not on appeal here. The retirement fund did not bring an appeal about that conclusion.
And Mr. Walsh, isn't this a de novo review? And so regardless, you brought the appeal saying that the retirement fund's interpretation is incorrect. And under a de novo review, we get to decide separate and apart from the trial courts and the administrative agency's decisions in order to address the issues that you raised on appeal.
Absolutely, Mr. Chief Justice. I mean, yes, this is a de novo review, and this court's view of the law is going to make its way into the opinion of that should control. The reason that I raised the idea that this was not raised on appeal from the fund, and this also plays into the second point that wasn't raised on appeal by the fund about the Chevron deference determination by the Superior Court. The reason that I raise it is because of the unique sort of situation that we're in here, where the result of an administrative agency was ultimately upheld, but not on the logic from the administrative agency. So, this sort of situation where the administrative agency does not have to bring an appeal because it likes the result, but the rationale for the result isn't the same as the agency's, I think is worth pointing out. And that's what I'm hoping to do here. So, of course, Chief Justice Carbolito, it's a de novo review, and you are able to say what the law means in this situation. I think the unique procedural footing here is worth pointing out. And the other reason I think that's worth pointing out is for the benefit of an appellant like Major Chargualaf. We have rules of procedure for this court that allow for cross appeals or for cross-firing appeals, for the issues to be briefed, for another round of briefing to address issues that an appellant or an appellee feel need to be addressed. Those weren't accessed here. So while it is de novo review, I think the interesting fact that the Superior Court rationale does not match the agency's rationale, but the result was the same, is worth pointing that out. And that's why I offer it.
Wasn't the trial court also looking at it from a de novo review as opposed to granting deference to the G? And in fact, it determined that the retirement fund wasn't entitled to deference because this isn't a situation where the retirement fund, it seems, at least the trial court was entrusted to their discretion to interpret any statutory ambiguities. I mean, there was the argument that the statute was unambiguous and plain on its face, and so shouldn't that have also been a de novo review?
Yes, Justice Torres, it's de novo review, and yes, the Superior Court of Guam, sitting as this court over the Superior Court, was conducting a de novo review of the law. But there is a second standard of review. Those are the substantial evidence standards. So there are factual determinations that part of our appeal is about the lack of a factual record that was developed at any level, including at the Superior Court, which could have conducted that review.
But how important really is the issue of a factual dispute here? I mean, you asked us to interpret the statute and grant the writ, and so if it's just a question of law that can be properly decided by the court, why is there a need to further develop the record? Either the record is incomplete and discovery has to be had before a final determination, or if there are no factual disputes and it's a question of law, we should be able to decide it de novo. So what is your position on that? Are there really factual disputes and a lack of evidence that warrants further discovery, or is this just strictly a statutory interpretation that we can examine?
The factual dispute that needed to be developed is the responses from the fund. This is an excerpt of record 36, which is really the only record item we have from the agency level, which is the position of the fund saying we have never done this like this under the law before. So yes, Justice Torres, I completely understand that I'm here articulating a read of the statute that this court can weigh in, and sort of that would simply be it. Here's the read of the statute, or I'm in another world where I'm saying we needed more factual development. But the reason I think I can advance both positions with a straight face to this court without trying to seem like I'm trying to have my cake and eat it too, Justice Torres, is because the fund's response to Major Chargualaf in the one-page answer to the petition he brought was, we've never done it like this before under the law. Our board of directors has reviewed. There's nothing. None of those facts exist in the record.
So is your challenge the process of how the fund arrived at its decision, or is your challenge the interpretation of the statutes and the resulting decision that the retirement fund issued?
It is both, Mr. Chief Justice, and that's because we think the statute is clear, as the Superior Court said. We believe the plain language of the statute is clear. But if the agency was going to take a position that our history, our way of calculating, our board's reckoning, our decisions, all these things that the fund suggested that it did, past history, the way we've calculated and we've always calculated, those sort of factual averments that were doubled down in the verified answer, right, which is a factual position, those facts, they're going to use those sorts of facts. We've never done it like this. We've never calculated like this. These calculations don't work. Then there's a factual bridge that must be crossed. So while our position was initially, when we brought our review for the retirement fund, was the law is clear, it should be calculated this way. When the fund's answer was not, the law doesn't read that way. The fund's answer was, the law, we've never done it like this in the past. I think there's a factual question that needs to be developed. And it's also one of the points of error that we raised. When the case was originally before Judge Barcenas, we had engaged in motion practice seeking some level of discovery as an SP matter. And I think this court in the recent DFS decision has made it even more clear that the Superior Court judges have the ability to fashion discovery in a means in an SP case as a civil action. One of the errors that exists here is the Superior Court's eventual decision, once we found a non-disqualified jurist to take this case on, that jurist did not cross the discovery bridge. We weren't given any position about that discovery. So yes, there is this discovery question about the facts that needed to be developed. And yes, at the same time, to this court, there is a de novo review about what that retirement fund calculation language means.
But I'm still not clear why an analysis of the retirement fund's own process of interpretation and what they did is necessary to the disposition of the case if we're deciding it on de novo through the merits of a statutory interpretation. I mean, what process they did, whatever, they undertook, while there might be some curiosity involved with that, I don't see how that affects our de novo review of the merits of the statutory interpretation.
Yes, Justice Torres, what I will say in response to that is, if the agency's record would have developed, why they made these conclusions, then I think we'd have a better understanding through the Superior Court and then the eventual Supreme Court level as to how they got there. So this lack of being able to explore what maybe even their legal thinking was, what was the advice they were being given at the time that the board was making these decisions. None of that's in the record. But I do think that
So in reference to, I mean, like the trial court had a deliberative process in which it arrived at it's a decision. So in reference to a decision that's made, are you also concerned in reference to how the trial court arrived at its decision? Or are you challenging or are concerned with ultimately what it put down in paper in reference to its resolution of your claim, your client's claim? To me, what you have brought is that you're saying that your client is entitled to have certain benefits that were paid out to be calculated as part of his average annual salary. And you set about saying how that statute should be looked at to arrive at your position. And the retirement fund did its own analysis, and that's what was before the trial court because you disagree. And that's what's before us. So how the retirement fund arrived at that, so long as there's no dispute as to the number of years of service, what the amounts that were paid out during the course of his tenure with the Guam Police Department, and what the amount is that was the back pay that was, those are elements that factor in to the calculations, which is, really for us now to determine what the legislature intended when it used the word service, annual salary, average annual salary, and how the retirement fund deliberated and formulated its thoughts to arrive at its conclusion, I don't think is important.
Well, respectfully, Mr. Chief Justice, I'd also add there's one other word that's important here. It's the word received. What did the legislature mean by the average annual salary received?
Yeah,
so
correct.
So that absolutely on that aspect of the de novo review. But what I do think is odd about this case is that the Superior Court of Guam, and we think in contravention of Perez, in contravention of State Farm, in contravention of SEC, these cases that say that you either give a thumbs up or a thumbs down to the agency's ultimate determination. In this case, we have a thumbs up to the agency's ultimate determination, which is Major Chargualaf is entitled to none of the calculations the way he reads it. But what we have is the Superior Court of Guam, we think in violation of Perez, State Farm, and SEC, supplanting its rationale for that for a vapid agency record. So the agency said Major Chargualaf is not entitled to this calculation. The Superior Court of Guam disagreed with the rationale, but then came up with a new rationale and then upheld the agency's determination. We think
I think that binary choice that you're referring to, that sort of you've got a either thumbs up or thumbs down. I don't know that that's an accurate reading of either Perez or Fagan, which Perez relied upon, or the other cases that Fagan refers to. I think that you still have a de novo review at the trial court and at our court of the agency's conclusions of law. I agree with you. There has to be a thumbs up or a thumbs down on the agency's findings of fact. And for sure, I don't think that the trial court could have taken a different position if it was going to adopt the findings of fact and then come up with findings of facts that were contrary to that. I don't think that's the same with the conclusions of law. I think the trial court was free to adopt its own conclusions of law. But I want to focus on the statutory interpretation
Yes, sir.
now, because I think that's really the crux of this case for me. I mean, you want us to focus on the word received within the definition of the average annual salary, and the definitions provide, definitions of service, definitions of salary, definitions of average annual salary. The fund tries to get us to focus on the years of credited service definition. And what does that mean? But to me, I think there doesn't appear to be a clear definition of what annual salary means. I mean, I think we can understand what an average annual salary is under the definition, the average of the 3 highest annual salaries received. That's what the legislature has set forth for us to take as the definition of average annual salary. But what is the definition of annual salary? What does annual salary mean? And how should we look at the word annual salary?
I think the easiest and fairest way to look at what average annual salary means is how the government of Guam treated it. And the government of Guam treated it by taking $30,000, $40,000 of taxes out of Major Chargualaf's particular salaries for any given year that he received those monies. The government of Guam took the salary out of it.
Well, what other year would it take the taxes out of than the year it was paid? I mean, they wouldn't take the taxes out if it's paid in 2014 and was attributable to service rendered in 2009. They wouldn't take out the taxes back in 2009. They take it out. And I think that's what the tax code provides, is that it's when the recipient receives the money. So what is annual salary? I mean, to me, I think that definition appears to be lacking in my view. What do you suggest as an annual salary?
The amount of money that the employee received in that year as payment for his work. Now, the statute. But
the work that he received in that year, all of the payment wasn't attributable to the work only in that year. I mean, in fact, it was attributable to work he had performed in other years, right?
Well, Your Honor, I respectfully say that I'm not sure that the record actually shows the straight line connection that the fund suggests here. There is money that is received, and it's money that's received by the employee because the legislature recognizes there was some previous work done. So yes, I see that, but this is not simply sort of a here are your hours of back pay award, and this is the exact straight line connection. The legislature gave these law enforcement officers lump sum payments in a particular year. This legislature has demonstrated its ability time and again to very consciously shape the annuity calculations with, as our compiler's note in the section shows, they've done it multiple times. They didn't choose to do anything like that here. So what we're left with is this situation where the Superior Court of Guam created a conflict, or found a conflict, and a conflict that I think under this court's statutory analysis teachings doesn't exist. The idea that you're going to take a general statute from later in time that the legislative record shows the Chairman Pangilinan making sure it was not going to change the annuity calculations, using that to justify a change in the annuity calculation, or adding language to what is the plain reading of the statute. So that's why I recognize that there's not a clear definition of received, but the record shows the employee received money in a particular year. Now, if the employee received sort of similar to, an associate at a law firm, if you get a bunch of money in this year because you were so great last year, oh, that's your salary for this year. You received it this year. The legislature is assumed to know what it means by received. Mr. Chief Justice, I see that I'm at 11 minutes, 30 seconds. If I can preserve the balance of the time or address any of the questions you have now.
Yeah, can I ask one more question? Could you address the issue of the fund with regards to what they say would be an absurdity for someone who retired before the lump sum distributions were paid, that under your interpretation, that they would not benefit in their annuity from these later lump sum distributions and would in fact receive less than they would otherwise be entitled to under the fund's interpretation of the calculation.
Yes, so what I'll say is that bluntly, not very fair processes or bad ideas or not well thought out ideas by the legislature is not enough to say that it's absurd. I think that members of the defined contribution plan could say, well, how is it fair? Why do I get treated differently than these ones before this other law gets passed? So I think I recognize that concern that I think Judge Lamarino specifically called it a fairness issue with his decision in order, but that's not absurdity in our read of what absurdity means. Could any rational legislature have never intended this to be the case, these extra benefits to these fund members? And as we suggest, with 23,600 voters who are fund members, that doesn't seem absurd to have been something that the legislature could have wanted. And I think that too is, if there is a concern from this court about what are the implications, Judge Barcinas in the Superior Court level said he recognized he does not have the luxury to consider those kinds of concerns. That's for the legislative branch of government. Thank you, Justice Torres. I'll sit down now if that's okay.
Thank you.
All right, thank you, Attorney Walsh. Attorney Vince Camacho, you are recognized.
Thank you, Your Honors. I just want to confirm everyone can hear me?
Yes.
Good morning, Your Honors, and may it please the court. Vince Camacho here for the Government of Guam Retirement Fund. Your Honors, I want to start off setting the framework for the fund's position on this type of challenge to the fund's determination as to how an annuity is calculated. Currently, the accrued annual liability or accrued actuarial liability is $3.2 billion for the retirement fund. The way we sort of translate that information is if the retirement fund had to pay out all benefits today, it would be required to pay out $3.2 billion. Currently, the fund has an actuarial funded the balance of $2.06 billion. That means that $1.15 billion is unfunded. And why is this a very important figure? Because right now it costs the government of Guam 26.97% of every single person's salary in the government of Guam in order to pay these benefits. And I put this out because 21% of that 26% is due to unfunded liability. Why is the unfunded liability an enormous burden, not only on the government of Guam, but most importantly, the people of Guam? Is because during the years since the inception of the retirement fund back in May of 1950, the legislature has twiddled and amended and proffered all a bunch of benefits that the government of Guam could not pay for.
Yeah, but Mr. Camacho, even though
Yes,
the
sir.
legislature, and I think they have expressed some concern themselves in 8101.1 for the excess level of benefits compared to other government retirement systems, they've also acknowledged that it's difficult to decrease the benefit for the existing current members. And so I'm not sure that we should be persuaded by the dire circumstances that the pension fund may find itself into, and other pension funds have been driven to bankruptcy because of it, when there's an equally important incentive that's been identified by the legislature of keeping qualified employees and providing an incentive for them to continue to work for the government of Guam. And so, you're trying to balance legislative objectives with the interpretation of the fund and of the language and the meaning of 8101 with 8104. And I'm not sure that the fund's financial condition should factor into our statutory interpretation.
That's correct, Your Honor, and thank you for that. My intent is not to sort of bridge those two together. My intent is to sort of provide a framework as to why the statute exists the way it does. For most retirement plans, what governs the plan or what governs the trustees with regard to the plan is the plan document. If you look at the DC plan, the 457 plan, those have separate plan documents which were promulgated by rules and regulations. The DB plan, which is the plan at issue here, the plan document is the statute. So you're not going to see additional plan documents that sort of provide or lay out specifics with regard to how an annuity is calculated, how contributions are paid, when they should be paid. Those are all, with regard to the defined benefit plan, statutorily provided for. And that is what is governs the trustees of the fund, as well as the director of the fund. And so my point is basically that this document, the legislature's intent is to provide definitions, which it did in 8104. And those definitions are not just plain meaning definitions. They are actually definitions that address specific issues with regard to the plan itself.
Now,
And
Mr. Camacho, let me, if I can just interject that, you know, while I'm sensitive to the context that you were trying to frame at the outset and not insensitive to that, because there are literally thousands of lives that may be at stake in reference to this very important case before our court. You know, we cannot absolve if the legislature, when it created the DB plan and specified the very generous benefits that Government of Guam employees enjoyed under the DB plan, that we're now going to rewrite that history, contrary to what, you know, the legislature intended when it set up an overly generous. Now, did it calculate whether it could afford that plan? It's not for us, you know, to question the wisdom of that policy, although it's not an abstract. I think as Justice Torres tried to emphasize, the focus is on what the legislature intended when it used those words in an overly generous fashion. And so I think that's the context and framework in my mind in reference to trying to resolve the issues before this court. And so you know, while context is not irrelevant, it is not determinative or constitutes a major part of how we should address past legislatures over generous ventures and actions in prescribing such a plan.
yes, thank you, Chief Justice Carbolito, and I completely agree, and so does the fund. What I was basically trying to do was to sort of narrow into why the fund's position in terms of why it interprets the statute the way it does, based upon Mr. Chargualaf's question, was because it has to be narrowly tailored to the benefit for all members and for all beneficiaries of the fund.
But don't you agree that the Retirement Fund Board of Trustees duty as trustees under the fund also have a fiduciary duty to interpret the entitlements as prescribed by the legislature and not what it thinks it should be, because that is how the fund should be administered. I mean, if the trustees has total discretion in reference to rewrite the statute, then there's not a need for us to be here.
That is correct, Chief Justice, and I don't believe the fund's position is that they can rewrite the statute. I think the fund's position is that we cannot look to the way the original or the plain meaning of certain words in the statute without taking a look at the statute in its entirety. So the focus of Mr. Chargualaf's arguments is focused on three definitions and the annuity calculations, but it fails to take into consideration that even within the retirement fund statute, there are other sections where it actually explains what is not considered pay with regard to someone's annuity calculations. For instance, and maybe some of you may not be aware, and I'm sure Mr. Chargualaf is aware because it mostly affects individuals who have a lot of overtime, night differential pay, and it's the issue of non-base pay versus base pay. If we want to take a look at the definition of the annuity, it is strictly based on base pay unless the individual opted in prior to April 1989 for non-base pay. And this is where the issue is that Justice Torres brought up previously with regard to what is really considered the annual salary. For purposes of the retirement fund, it is not every penny that someone receives in the year, because, for example, in a police officer's, he's claiming he makes $103,000 a year or 113, whatever the number is. But in reality, based on the statute, the computation for the annuity is based upon base pay. If that individual chose the non-base pay option, that's when the additional salary for that year would come in. So any person receiving...
Does that create a factual issue in this case for determination of whether Major Chargualaf had elected to contribute based on non-base pay or base pay and what would be included in his annuity calculation? So should the case be remanded for discovery on that issue?
No, Your Honor, because I mean, we're not disputing the issue of base or non-base pay. Mr. Chargualaf's position is that we should take his W-2, and whatever the W-2 states is the number that we should use in terms of calculating his high 3 average annual salaries. The problem with that is the W-2, and everyone knows, the rules and the instructions for W-2 for Box 1 is taxable income. Taxable income is defined by the Internal Revenue Code, and in Guam's case, the Guam Territorial Income Tax Code. That does not have the same definition as salary or base pay or non-base pay with regard to how the fund computes an annuity. So basically, someone's base pay, everyone knows if whatever your high 3 base pay is now, is what you're going to use. But in Mr. Chargualaf's case, because perhaps he did opt for non-base pay, the fund doesn't disagree that whatever non-base pay was earned during those periods would be calculated in his annuity. The big problem and the big issue, and why I brought up the context earlier, by using the W-2, it doesn't compute in terms of what the average annual salary or what even an annual salary is for purposes of the fund's computation of annuity. If you take a look at the W-2, if someone had a 457 plan, if someone had a 403B plan, or even a cafeteria plan, those numbers would be excluded from Box 1 and would not be considered salary. So to use Mr. Chargualaf's argument is that we have to use what he got in that year contravenes what the DB statute does, but also contravenes the purpose of what the W-2 is for. The purpose of the W-2 is for taxable purposes only. It's not for purposes of computing someone's annuity based upon the statute. And I think we really need to take a close look in all of those definitions, because what Mr. Chargualaf fails to consider, and probably even the lower court, they totally disregard the word credited service. Credited service is a very important term because it's, yes, your salary for the year that you received, that's correct. But for the credited service in which you were entitled. So, I mean, to allow this type of calculation, what have we seen in the last, just within the last few months, or even just last year? The Port Authority, when a lot of the Port Authority employees who were wrongfully terminated were reinstated. Some of their back pay was $700,000. So does that mean if the Port Authority paid $700,000 and in 2020, and they retired this year, that the fund is required to use that $700,000 payment for purposes of computing the average annual salary? And I think that's where the lower court got it right, is that, yes, we have the plain language in one, the plain meaning on one, but this very court in Sumitomo specifically said that if it leads to absurd results, and we've also identified this in our brief, that this type of interpretation would lead to disastrous results with regard to the unfunded liability. And it's just
an ambiguity? Is there an ambiguity in the statute that allows us to look at other rules of statutory construction? Do you think there's an ambiguity in the statute, or do you think that it's just a different read of what the plain meaning entails? I mean,
I would fashion to say, Your Honor, that the fund's position, because it's always calculated on an individual's annuity based upon the way it's providing, or the process that we're putting forth today, is that there is no ambiguity, but you have to take everything together and not just say salary, received, equals average annual salary. I mean, we want to take a look at the definition. When you're looking at the definition of the contract.
I'm not understanding that argument that there's no ambiguity. You want us, the interpretation that the fund is advancing is that the emphasis should be on when it is credited in terms of the salary. Credible service, I think, is what you, as part of that definition that you wanted to emphasize, whereas Mr. Walsh is saying, no, let's look at when that is received, when the payment is received. So to say that, there's no ambiguity in the statute that is at issue in terms of 8104 and 8122, it's difficult for me to follow.
Yeah, I think I think Justice Torres hit the nail on the head when he was trying to differentiate. It's not an ambiguity. It's a fund's position that the way it's interpreting the statute at this point is not ambiguous to the fund if read in conjunction with all the other provisions of the statute, such as whether non-base pay would be included. Because if someone who did not opt for non-base pay, it would be irrelevant as to how much they made for that year, because the calculation is strictly on someone's base pay. I mean, the calculations are extremely, extremely complicated when someone says, I want to retire. I mean, the funds process is actually, you go through every single pay period for the last 34 years to ensure that whatever the base pay is, that's your base pay. Unfortunately, the fund doesn't have
but isn't
the
the
luxury.
Isn't the ambiguity, as just Doris pointed out, that what really may be pivotal is what does annual salary mean? And annual salary is not defined in the definitions of the statute. I don't see a definition of annual salary.
That is correct, Your Honor, Chief Justice. But when you bring in the calculation with regard to when someone's, and you take a look even at the contribution provision of the statute, the contribution provision of the statute says base pay. So it doesn't, if you read that provision, the definitions in 8104, in conjunction with 8122, and you took a look at how the contributions are coming in and whether someone's on the non-base pay or base pay option. In other words, if you may recall the terms inclusion and exclusion back in the 1989s, when the fund actually stopped that practice because it did cost a lot of money. But I think the gist is the way the fund interprets the statute is not just looking at 8104 with regard to the definition there, 8122 with regard to what that annual salary is, but also in conjunction taking a look at what the definition of base pay is with regard to contributions. You know, we've been through this before with regard to many challenges and many individuals' interpretation of what the language says. And perhaps we're at a pivotal point, like you say, that requires us to take a look and ensure and perhaps go back to the legislature to make sure it's clear. But this doesn't change the way the fund has been interpreting the statute since 1950 and how it's been computing annuities for every single Guam retiree since 1950. I think
you
it's
keep bringing up the fund's interpretation of the statute and the process that it undertook to interpret the statute and how it's done these calculations in the past. And that was one of the issues that was brought up by Mr. Walsh, that it would be important for them to understand what that process was. And, you know, that was part of his claim for wanting to have discovery to determine, you know, for example, whether the requirements of the administrative adjudication law were met, to weigh the veracity of the legal contentions, ensuring that there was fair treatment across the board for the calculations. So isn't that something that we should potentially look at?
Well, I mean, the petition that was set forth before the board was to ask the board to consider Mr. Chargualaf's interpretation on how to calculate his annuity. So, I mean, even if you were to go back and allow discovery and someone says, I mean, we don't even know where to begin with regard to whose file do we look at and how we calculated that individual's. And in reality, it would sort of be irrelevant at this point in time, because if, for example, they did find one, all the fund had to do under 8122.1 is make the adjustments as required by statute if there was an error made. I think what's before this court is whether Mr. Chargualaf's calculation is the correct interpretation of the statute. And we would argue that, you know, perhaps the plain meaning is the plain meaning, but the way the fund takes a look at this, I mean, you have to understand the Board of Trustees of the Retirement Fund is the only board in the entire government of Guam that has a fiduciary duty that could be held personally liable for the outcome of any decisions that they make. So they take this job quite seriously. And, you know, as a matter of fact, they're in a position where they need to protect the beneficiaries of the fund, and the consistent application of their interpretation of the statute is, you know, highly regarded to them. And so we're here in a position to, you know, Mr. Chargualaf is here asking the court to consider his calculation. I don't think discovery is going to change the request for the court, because even if there was a document that said, or there were records, I can tell you that there are no records, and that's why the fund offered the affidavit of the retirement fund, because the fund just implemented the plan the way it knew how, as they were instructed to. Again, the statute is the plan document. So there are no additional plan documents in which the Board of Trustees said, well, we're going to take this provision and we're going to go through the administrative adjudication process to determine this. I think the way the fund has been calculating the annuities up until this time has been deemed, you know, a correct interpretation, and the fund will stand by its interpretation until such time this court, makes that determination. But it's
Now,
very
the
important.
fund, Mr. Camacho, the fund continues to advance on appeal that the retirement fund's decision and its analysis is entitled to the Chevron deference. And I have, in my understanding of the Chevron deference is, we look to the express wording of the statute and where the legislature intended to specifically acknowledge the unique abilities and character of the entity implementing that statute, that's where it may be entitled to deference, and because it best knows how to apply a unique statutory framework like the Atomic Energy Commission. Here, number one, we don't have any expression by the legislature to that effect. Number two, we have definitions that have been provided in which the legislature says, this is what we meant, or this is what we mean when we use these terms. And, it's here in front of us under a de novo review. I don't think anyone questions that, and because it's an issue of statutory interpretation. So why should we give deference to the fund in reference to what they feel the legislature meant when it used those words in the formula for calculating someone's retirement entitlement?
Thank you, Chief Justice. And with regard to the Chevron deference, whether the court grants the fund deference in that regard, we've actually briefed in our briefs, we've actually cited several cases wherein the unique situation that a board of trustees sits in with regard to a pension fund or with regard to a retirement fund gives deference to the board of trustees on how to implement the plan. Again, they stand in a fiduciary duty to the members and benefits, to the beneficiaries of the plans in which they administer. They don't give any deference to the government. And that's why on many occasions, the fund has actually sued government of Guam in order to make sure that contributions are paid, in order to make sure that prior to retiring anyone, that all the contributions and interest and penalties have been paid as provided for in the statute, because they do not have the ability to waive any of the provisions in the statute. They are merely.
I don't think this case is a challenge to the trustees' enumerated powers under the fund in terms of its fiduciary duties and responsibilities. I don't see it as a challenge to the trustees' fiduciary duties as enumerated in the two sections provided in the retirement fund structure. It's a claim that a government of Guam employee says they're entitled to, they've earned it. This is how the statute says it should be calculated. And so it's more a determination as to what the legislature meant when it says that we'll figure out your entitlement is based on your average annual salary for the 3 highest years in which the service, there's credible service that you're going to be paid out for. And it's now just us for determined that the legislature mean when the non-base pay was earned or when it was received, when the payment was received. And I think the issue, may be somewhat difficult to determine based on the language of the statute. It doesn't get into fiduciary responsibilities.
Yeah, just as a follow-up on that, I also don't see it as a question of the court interfering with the plan's administration of the DB plan or the exercise of a discretion by the trustee that's vested in them, but strictly one of just a statutory interpretation. And that's how I view it.
That's correct, Your Honors. And I think the fund's position is this. If they were to, let's just say, accept Mr. Chargualaf's calculation, we go back to the effect of that decision, to the increase in the unfunded liability, because it's not funded. These benefits that will be based upon an individual when they received it is not funded. It's also not fair to the employees who worked straight 30 years and put in the time.
Let
And
me ask this, Mr. Camacho. If the legislature had intended that because of its, out of the goodness of its heart, didn't take into account how it was going to pay it, but just that as a government of Guam employee, you have this retirement fund. These are the benefits that you're entitled to. And that's what we're prescribing. Are we then at liberty to say, well, you know, you didn't take into account how to pay it, and therefore this is really how it should be administered?
I think, Chief Justice, you hit the nail right on the head. I mean, even with the Superior Court's order, which governs the fund at this point in time, the fund cannot do anything with any future legislation. And that's why you'll notice every time there's new legislation, the fund's position 9 times out of 10 is we're not going to state a position on this, but if you are going to grant this benefit, or if you're going to allow this benefit, it has to be paid for. The fund is merely in an administrative position. It doesn't necessarily make policy. So it has to abide by the terms of the plan document or the statute as prescribed, and taking into account all other sections.
I think you've just answered the Chevron deference question by those statements. And I note that you are over by 39 seconds. So
I'm sorry. Thank you, Your Honor.
I'll give you a minute to wrap up, and then I'm going to recognize Mr. Walsh.
Okay, thank you, Your Honor. Yeah, the fund's position, Your Honors, is that Mr. Chargualaf's calculation, while may have merit with regard to the plain meaning of the language, it's just to apply that type of calculation contravenes the current funding levels of the fund, which could put the fund in a dire situation, number one. Number two, the results are unfair to the government of Guam employees who don't get these types of back pays, or are maybe fortunate enough because their department couldn't pay overtime. And we were seeing this now with the police department and the COVID response, that Gov't Guam is not able to pay the overtime and the differential pay on time. So all the work that was done in 2020 probably won't be paid until 2021. So their pay and their high annuities are going to be adjusted based on the discretion of the government of Guam agency, or when the government of Guam is able to make these payments, which puts the fund in a situation where, yeah, it's not based upon funding levels that's required by the actuarial report, but rather it's based upon when Gov't Guam can actually find the cash or the time to pay it. That's just not how you run a retirement plan. It's hard for the fund board of trustees to try to figure out what the cost is every year, and then try to figure out how they have to get it funded through the legislature. Thank you, Your Honors, for their time.
Thank you, Mr. Camacho. Mr. Walsh, you may use your remaining time. You need to unmute yourself, Mr. Walsh.
Thank you, Mr. Chief Justice. I hope that's better. I want to thank you, Chief Justice Torres and Justice Castro, for these considered arguments. Major Chargualaf and I, we understand the significance of the question that's posed here, the sort of point that Mr. Camacho ended on. I'm an attorney trying to find my own retirement plan. And my retirement plan that I eventually find will bear no resemblance to the plan that Major Chargualaf has or my father had as a longtime UOG professor. We are well aware and understanding that, you know, the authorities cited by the fund that Joe Kent says there's a Hawaii public pension debt crisis and that there are doom and gloom across the United States because of these funds. But I think this court can certainly take judicial notice of what happened in Saipan with its fund and how its legislature, when faced with these questions, legislated the policy solutions that are needed, not its courts. And I think that it is what needs to happen here. That if these questions of fairness or policy issues about how these benefits would flow to DB plan members, maybe equal protection issues because some agencies get base pay calculations done differently, that's in the OPA report. All of those are for the legislative branch of government. The invitation from the retirement fund to engage in a sort of Lochner-ian, you know, we don't like the hours for the bakers kind of jurisprudence simply has been rejected before by this court, and it should be rejected again. What does the statute?
Mr. Walsh, in reference to the DB plan, you know, that plan is closed off already, and benefits have accrued. And so can the legislature go back and rewrite the statute that will affect current members?
I think that's one of the reasons that the Administrative Adjudication Act must be accessed. I mean, if the retirement fund was going to come up with new ways to implement new legislation and have comment periods and allow you know, old fund members, DB fund members to come in and opine on new laws passed by the legislature, I think that will all get fetted out. Where I stand here today, though, I'm not prepared to say that can't be done. The legislature in Saipan has been confronted with this and has legislated toward a solution. So I think that's for the legislature to decide. And in terms of the hypothetical, could that be done? You know, what is the law? I haven't briefed that. I don't know. I think the legislature could legislate these issues. But I think more importantly, Chief Justice Carbolito, is the fact that the legislature did not, despite the compiler pointing out that our legislature knows how to adjust the annuity calculations. Even the fund's argument today about how there are check the boxes, you know, these back pay things are not included, these other kinds of pay are not included. The fact that those boxes don't exist means that the legislature did not want them to exist for this type of pay. So I think the legislature could take action, but I think more importantly to that question, Chief Justice Carbolito, is the legislature did not take action when it could have. So what we are left with.
But realistically, Mr. Walsh, so what you're saying is that the legislature could easily fix this, but where, you know, they're elected officials and, you know, they face the voters every 2 years. And so an easy fix is to go back and take away entitlements to these retirees, or those who would be retirees who have entered employment under certain rules and under certain understanding of entitlement. So do you think that's such an easy legislative fix?
No, it is not. And again, we've been involved. We know about what has gone on in Saipan and know how those legislative fixes are difficult. I would not presume to say that an elected branch of government has an easy job to address these issues, but they've demonstrated their ability to address these issues. The fund recognizes that the legislature comes to the fund, gets consulted on what we're going to do next, and then makes decisions. I understand that is a difficult process, but I think as Judge Barcinas in the Superior Court recognized that excerpts of Record 108, when that jurist said, well, what happens if Mr. Walsh and Major Chargualaf are right? What happens if we're right? There's going to be all sorts of problems, difficult legislation perhaps. The court said, unfortunately, that's not a concern that I have the luxury of considering. I'm doing a statutory analysis. That was the Superior Court, and I think that Superior Court is right. I respectfully, I do understand that this court has time and again had to weigh in on issues of public policy or concerns about what would be the next legislative move or how that can be fixed. But in this case, where the legislature has a history since 1950 of knowing exactly what it's doing with its retirement fund, even perhaps if those are not the best financial decisions to make, but they know what they're legislating, I think this court is fine in making a decision and letting the legislature decide what the next legislative move should be. As difficult as that might be. I would also like to say, if I could, a little bit more about this question about received, and offer one other point on that. You know, the word received is actually in the statute that was being analyzed here. The word creditable service is elsewhere, right? It's after. This word received is in the statute. And I think that if we were to ask an employee what they understood it was meant when you received your salary, the employee would understand that to mean when I took it. So what is the benefit of the bargain expected by the public service officers and the employees of the government of Guam when they read their annuity calculation statute and understand how it's going to get calculated? At least from their perspective, and perhaps this court will disagree with it, but at least from their perspective, I would submit that their perspective it's when they receive the funds. The idea too about the points raised by the fund about base pay versus non-base pay.
What about Mr. Camacho's illustration that, for example, the Port Authority employees, one employee received back pay of about $700-some thousand dollars, and under Major Chargualaf's interpretation, then that should be part of the computation in terms of one of the highest 3 years average annual salary. And the same employee or an employee under the same category who works diligently during all those years, who was paid regularly the same salary amount, there's going to be a gross disparity under Major Chargualaf's interpretation in retirement entitlements if your interpretation of the statute prevails.
To be frank, Mr. Chief Justice, I don't know enough about the retirement funds calculation regimes for that. But from what I understood Mr. Camacho to say, though, was that they have an established process of how to deal with that. Right? There are boxes to check.
Well, let's pose the hypothetical. I mean, the hypothetical is that under if Major Chargualaf was in a similar position, and there was an adverse action, and he was out of the Guam Police Department for 3-4 years, 5 years in fact, and then he prevailed at the Civil Service Commission and is paid back pay of $700-some thousand under his interpretation. That should all be and it's paid out before he retires. That all should be calculated in the year that he receives it. And whereas a similar comparable colonel, maybe a police officer who just receives a salary during those years, and they both retire, a good major is going to have a substantial retirement, more than the colonel who didn't receive any substantial back pay during his years of service to the government.
I would be very concerned about the equity of that situation if we were talking about two individuals who received back pay judgments from the Civil Service Commission. But the hypothetical is posed, and the position raised by the retirement fund, that's a back pay award from a Civil Service Commission after an administrative hearing with a record that's developed. The issue involving Major Chargualaf is factually very distinguished from that. It's separate. This is a amount of money paid to this worker in recognition of his work done, that he recognizes that he logged as salary on his W-2s, that the legislature commanded should be paid. That's very different than Mr. Miller and company at the Civil Service Commission saying, here's a back pay award pursuant to our processes. And if I understood the fund correctly, those processes are well recognized and they have their forms and they have their established mechanisms to do that, to deal with that, but not in this situation. So I would distinguish the two situations in your hypothetical, Mr. Chief Justice, based on the origin of the money owed. So the back pay situation, distinguishable because an administrative hearing for the Civil Service Commission on the back pay award, this is the Guam legislature giving a benefit and giving funds to the employees of the government of Guam.
Well, what about the other example, though, Mr. Walsh? And I know your time's up, so I'll end on this question. The other example where Major Chargualaf, if he had retired in 14 before the lump sum distribution was paid, he would still receive the lump sum distribution, but it would be paid in a later year. Under your calculation, wouldn't that affect his retirement calculation? So he would actually potentially not receive the benefit of having that money entered into his calculation?
Well, I understand the difficulty there, but I think that difficulty is more for, so with respect, Justice Torres, if I was trying to certify a class of workers, for instance, and then we could say, well, the workers that retired before Dayton got the money didn't receive it as salary in the same way that a currently working government of Guam police major received it as salary. Those are distinguishing characteristics there that I think would help say that maybe these two men should be treated differently. But in terms of an active employee receives money while working in the paycheck, I think that employee is fine to consider that salary as opposed to retirement annuitant who knows he or she is receiving an annuity.
Yeah, but the argument is that payment received is attributable to the period that he earned it or credited it, right?
If I may answer that question, that's the fund's argument that it's attributable to the year credited. Our position is the simple one: salary, the year received. And in the situation posed by you, Justice Torres, I don't think that would be considered salary. It comes after somebody's already left government service. So we'd have to find some other way to deal with that. But in this particular case, in this particular situation involving the major, there's been no record showing why it should be done otherwise, other than just the factual averments of Paula Blah saying we don't do it that way. And I think because he received it as an employee and its salary, it should be treated as the statute directs. And unless this court has any other questions for me, I'll thank the court for its time, Mr. Camacho, for his considered argument, and say thank you.
Thank you, counsels. We appreciate the arguments advanced in this difficult issue facing the court. The court will take the case under advisement and issue a written opinion at a later date. At this time, the court will stand adjourned. Thank you.